Welcome to Avoidance of Foreclosure and Eviction section of the Dodd-Frank Prep course brought to you by NHNLA, Unit 6C, Rental Housing Counseling. Section 6.6. The purpose of rental housing counseling is to assess the client's current housing and financial position, as well as identify the issues that are preventing the client from remaining in the home or from finding a home to live in. The purpose of rental housing counseling is also to educate the client and help them make changes and decisions to meet their housing goals, to provide a supportive role with a written plan of action and follow-up to help the client to be successful and remain stable in the long term, and then finally to provide referrals for other community services and programs to maximize access to opportunities and success. So let's start with resolving disputes. It is important that renters read and understand the lease before they sign it. The terms and violations of the lease are usually identified in the contract and can help to clarify the roles and responsibilities of those involved. A housing counselor should work as an advocate for the individual or family to try and mediate the situation with the landlord, tenant, roommates. Dates, times, and notes regarding the contact should be documented in the case notes. And it's highly recommended, and actually HUD requires that you use your client management software to document all this information. So you want to make sure you have an intake form, client authorization form, credit report, work plan, your client log notes. Make sure there's a HUD number, a budget that you've worked with your clients, and all supporting documentation. And this information is on page 2 and 3 in your manual. If communication and advocacy from the housing counselor do not work, or if the incident is of a more serious nature, such as discrimination, etc., the client should be referred for legal advice. Remember, you are not an attorney. Leave the legal matters to the pros. And I reiterate this over and over. You are not an attorney. And you may think you may have experienced a situation personally, or you may have witnessed a situation as a counselor or as a family member or friend or what have you. But you cannot give them legal advice, because as soon as you do, you can be sued for giving legal advice, especially if it doesn't work, is usually when it happens. And you don't intend to, but just be very, very mindful. If there's an issue, especially when it comes to discrimination or something of a legal nature, just refer them to local legal aid, or if you've got a relationship with some pro bono attorneys, go ahead and refer them out. Understanding landlord-tenant rights and responsibilities. Tenant and landlord rights and responsibilities for all rental housing units can vary state to state. Below, we're going to see a sampling of some of the most common. For tenants, follow the lease terms, rules, and regulations agreed upon with the landlord. That seems pretty self-explanatory. Keep the unit clean and safe. Follow local health and safety codes. Remove and dispose of trash. Again, very self-explanatory. Do not damage the unit on purpose. We should say do not damage the unit, period, but definitely on purpose. Do not disturb your neighbors. Landlords must be let on the premises for repairs and inspection with notice. And then receive security deposit refund within a limited time, or receive written notice with a set period of time. And basically what that last part means is after you leave, you should get your deposit back within a limited period of time. So they can't just take a year to get your deposit back. It's got to be a specified amount of time. And then if there are repairs that have to be done, you should get that as well. You should get a list of the repairs, how much they cost, and then if there's any refund due to you, when you'll get that. So it's important to remember two things. And I know we don't want to hear that, but yes, landlords have rights too. Having been a landlord, I think this is very important. The client may not always tell you the whole story. I know, right? We never have clients who walk in the office and only tell us their side, right? they always come in objective. So make sure you keep that in mind, that there's always two sides to the story. Tenants must keep up their side of the agreement as well. Landlords must keep up their side. It's a partnership here, and ramifications occur when one side does not. Each side is mutually exclusive. Now, I know you're like, what do you mean by mutually exclusive? This means that both sides do have rights and responsibility. The landlord must keep the place up to code, even if no rent is paid. They cannot turn off the utilities if the rent is not paid. On the tenant side, the tenant cannot hold rent ransom. The tenant cannot make repairs and charge the landlord without previously getting consent from the landlord. The tenant can sue for actual damages, though, such as motel costs in case of no heat, but the tenants must have receipts. Now let's look at some additional responsibilities, rights and responsibilities that landlords have. They can collect rent in a timely manner. They need to repair and maintain the unit safety. They need to follow all building and housing safety codes. They need to enforce rules and regulations fairly. They need to provide working plumbing, water, heating, and air, and keep the common areas clean. Landlords do have the right to go into their buildings, but they must give warning. And if you want to see the tenant and landlord rights, or the ones that we've gone over, they're going to be on page 4 in your manual. In most states, 24 hours written notice is deemed reasonable. 48 hours if you're in Rhode Island, Delaware, and Vermont. So check your state to make sure you know what your regulations are. In case of emergency, such as fire or water leak, the reasonable notice does not apply. That makes sense. So now let's talk a little bit about lease agreements. A lease should contain the following information: property address, name of the person responsible for the lease, person or persons responsible for the lease, the length of the lease, and the rental rate. In addition, the date the rent is due, the fee schedule for late payments, and where to send the payment should also be included. It must be signed and dated by the tenant and the landlord. Before signing a lease, it is important that the client understands the terms of the lease. Although there are many differences in leases, one major common difference is the length of the lease. And some landlords require an annual lease, and others give options. Although the annual lease is the most financially stable for many clients, housing counselors should assist the client in choosing the best type of lease that meets their needs. So if you know it's someone that's working temporarily and there's the possibility that they may need to move or relocate, then a one-year lease may not be the best option for that particular client. So make sure you know their needs. Now, property rules and regulations. The Rules and Regulations contract is another document that is signed between the tenant and the landlord. The document defines what can and cannot be done in and on the property, as well as the limiting uses of the property. It's very important that the tenant understand and follow these rules. Violating the rules and regulations of the property can lead to legal action against the tenant that can end in eviction, and that's not what we want. This document can also be part of the lease and not necessarily a separate form. Any questions or comments? All right, we'll move right along to security deposits. Actually, no, I have a question for you. When would a weekly lease be reasonable? A weekly lease, you say? Well, if they're staying in a boarding house may rent weekly because they're waiting for an apartment that may not be available for 3 months. So they don't want to get a long-term lease somewhere else, but this apartment is really where they want to be. It's in the school district they want to be in. It's the price range they want to be in, so they're willing to wait. So they might do a weekly lease. So you may see that sometimes. And then, of course, the month-to-month lease. All right, just wanted to throw that out to you. Now, let's move on with security deposits. And in your book, that's going to be on page 6. This fee is used as a financial guarantee to protect the landlord if there is damage to the unit or the lease is broken. The amount charged can range from half a month's rent to 2 months' rent and is held by the landlord for the length of the lease. It is typically a refundable fee at the end of the lease. Tenants must give written notice of their intention to vacate the property according to the lease agreement. Failure to do so may result in loss of their security deposit. Tenants can protect their security deposit by completing a final walkthrough with the landlord and getting written documentation of the inspection and any issues that were found. So if everything looks great, you should be receiving all of your security deposit back. If there's major damages, then don't expect to. Once the tenant vacates the unit, the landlord is given a set amount of days to inspect the unit and determine if any damage beyond normal wear and tear has been done. If there is damage, the landlord must provide the tenant with a list of problems with the amount charged per item. So not just a total, oh, the house needs to be repainted, the floors need to be redone, total amount equals X. They must break it down. This is how much it costs to paint. This is how much it costs to clean the carpets, etc. And it has to be beyond normal wear and tear. Ooh, evictions. Dun, 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 dun. There are 3 types of eviction notices that can be used. Terms and time period requirements for each one can vary state to state. So make sure you're aware of what is eligible or required in your state. You've got the pay or quit notice, which basically says pay the money by a certain amount of time or you need to leave. We've got the cure or quit notice, and that is usually because of some violation of the lease term, and you're given time to fix whatever the issue is, and if you don't, then you have to leave. And then lastly, we have the unconditional quit notice, and this basically says leave, period. They're not giving you time to fix or turn in any money. Maybe that time is already expired and now they're saying, look, you just need to get out. It can also be used to evict a tenant who continues to violate the terms of the lease, rules, or regulations. And once the initial notice is posted and the set amount of time is expired, the local municipal court begins the process of eviction. Tenants do have rights and can take their complaint to the municipal court to fight the eviction, though, if they feel like they've been wronged in some way. Agencies need to consider that many of their foreclosure clients are rental counseling beneficiaries. And that's very important because a lot of agencies now are thinking, well, you know, HAMP is going to end in 2016. It was 15 until very recently. So 2016, and we need to start looking more towards pre-purchase, etc. But just know that a lot of those clients may not be in a position right now to purchase, but they still need a place to go. So now they're becoming your rental clients, and that's another source of revenue for your organization, as well as another, avenue that you can help your community. So be mindful of that. Clients that do not keep their home need rental counseling to avoid homelessness. And many foreclosure prevention clients may have not rented in several years, if at all. Yeah, some people may have gone straight from their parents' home into home ownership. All right, now renters in a foreclosure property. That's a little bit different. Due to the recent increase in homeowner foreclosures, many renters are finding themselves in rental units that have been reclaimed by the bank note. And what that means is they were renting in a house and their landlord couldn't maintain the payments. Maybe they've been paying the landlord, but the landlord has been maintaining their payments because they're out of work, and so they've been using the rent payments to live off of. So the house becomes foreclosed. What then? Most of the leases become invalid, and the tenant remains in the unit on a month-to-month basis until the institution wants to evict them for the property. Some states are beginning to create tenant protection laws for this type of foreclosure situation, which is very good. But beware, there are a lot of foreclosure property rental schemes out there. Beware. Legislation was enacted to give renters more time before they were evicted from a foreclosure property. Bill S-896 was signed and enacted on May 20th, which provides renters with 90-day notice before they are evicted. So that is really wonderful. It's part of the Protecting Tenants at Foreclosure Act. And here we go. And this is a federal response to the plight of renters in foreclosed properties, providing critical safeguards to innocent renters caught in the crossfire of a housing crisis that they did not create. Now, the PTFA requires that the new owner of a foreclosed property to allow renters with bona fide tenancies to reside in the homes for the duration of their lease agreements under the original terms. For renters with short-term leases or no lease at all, the PTFA requires that the new owner provide renters with at least 90 days before requiring them to leave. Currently, this law is set to sunset at the end of 2014. So I'm hoping since HAMP was extended, this will get extended. But right now, it's set to end at the end of this year. Now, a tenancy is considered bona fide as long as the tenant is not the mortgagor or the child, spouse, or parent of the mortgagor. 2, the lease is the result of an arm's length transaction, so no interested parties here. And then 3, the rent is not substantially less than the fair market rent for the property. So if you've got a lease for $1,000 a month on a 2-bedroom house and most of the houses in the neighborhood are going for $3,000 a month, that's not a bona fide tenancy. But if everybody's around, between $800 and $1,200, and your lease is for $1,000, and it's not a parent or a child or a close relative, then you're okay. All right, that is the end of Unit 6C, Section 6.5, Rental Housing Counseling. Thank you.